Thank you for tuning in our next class for the law of evidence. I hope everybody has gone through our first video and you have understood what is required of you as a student. Today we are going to deal about sources. When we say sources, we mean sources of the law of evidence. That is very important. If you say sources, we're not talking about sources of evidence. Yes, so we are talking about sources of the law. Where was this law derived from? How did it come about? So it is very important that we make sure that we understand everything that has got to do with the law of evidence. So we shall begin with the fact that students must be able to source out the law. Students must be able to know exactly where do you go if you want to support your argument or if you want to rebut the argument. That is now the sources of law, and also the knowledge of criminal law is very important. The knowledge of criminal procedure and the knowledge of civil procedure will be very important for any student to be able to traverse this course without any difficulties. It is also important that you must be able to communicate competently in English and be able to write English. I see that there are a few of you who are struggling with this, and it is very important for all litigators to be able to do this. And you must be able to study independently. You don't have to go to groups all the time. You must be able to do your work independently and also do a lot of reading. I cannot overemphasize the need of a lot of reading in order for you to master this course, and also be able to extract and analyze information from all sources of law. Sources of law will be your legislature, your decided cases, yes, decided cases are the common law. So you've got to be able to source your information from these various sources of law, right? And also must be able to access resources right from the library. Like I was saying, if people do not know what is meant by volumes, and I need to stress this so that everybody understands where does the word volume come from. Volumes will be volumes of decided cases or judgment that are compiled in different books. We might have a volume that was compiled and finished in January, right? We are now in March, finished in January, and that volume will be volume 1. And we will have another different set of judgments that were compiled in March, right? And compiled into a book, those black books that you'll find in the library, right? And that volume will be maybe volume 7, depending on how many books were compiled by the same publisher during that year, right? It will be 2023 volume 7, 2023 depending, volume 8, volume 9, and so on, right? Depending on how many they will be able to compile in here, or how many judgments were compiled. And you must know that cases that are mostly compiled are what we can call reportable cases. That is now landmark cases, right? Ground breaking cases, something that it's never heard for, or cases that overrule other previous judgment, right? Of stereo decisions can also be overruled by a new law. There's been so many of them that have been overruled, right, by groundbreaking cases. So you need to be able to access sources of law, like in the library, where you access law reports. And also there is something called electronic sources, the electronic library, right, where you will go to what is known as electronic library and source out cases. In most cases you'll find that electronic publishers, like I think it's Lexus, normally don't have volumes. You just cite the case. You'll cite Peter versus David, and you state the case number. It will just pop in if it's in their library. So you may not have, the citation will be State versus Peter, and it's the the case number. That's how it's going to be cited. There will be no volume, because electronics are able to take a lot of decided cases in big volumes, that there's no need to put them in compartments to say this is volume 1, volume 2, volume 3. So you must be wary of that as a student, right? So let us now get on the gist of our lesson, which is sources. That is now sources of the Evidence Proceedings Act. I think it's 25 of 1965. So let us get into that and see how did it come about. Where is it derived? Where did it come from? So we'll remember that South Africa was once a colony, but not the whole of South Africa was a colony. Colonizing of South Africa started in the year 1806, where British forces landed at the Cape with the aim of attacking and conquering everyone who was an inhabitant of what is now known as South Africa. So it started with the British in 1806, right? If you read your history, it will say the British settlers, 1820 British settlers. No, it actually started in 1806. That is where the war to conquer started. It ended in 1820, where they were then declared as having successfully conquered the Cape Colony, not South Africa, the Cape Colony, in order, where they ended up conquering the whole of South Africa. Remember the Frontier Wars, the Anglo-Boer War, the war with the Zulu Nation at Isandlwana. Those were all the wars that culminated in the English being able to conquer South Africa, so that they could enforce their laws. That is now the English law. That is why our common law is actually derived from the English law, right? So Those will be the sources of our lesson that is now the law of evidence. Okay, that is how it started. There was a different law that dealt with evidence, right, in the Cape Colony, because you must remember, South Africa was divided into 4 provinces. Before these 9 provinces, there was 4 provinces. There was the Cape province, there was Transvaal province, there was Orange Free State, and there was Natal. All these provinces had their own laws, because you must remember, Orange Free State was predominantly Afrikaans, so was Transvaal, and Natal was predominantly English, although there were Afrikaners, but it was predominantly English. Okay, and the Cape of Good Hope, so the laws there were English laws, because it was successfully conquered by the English. So the colonial laws, what is called the colonial laws, are the sources of the law of evidence, right? That was done in the Cape Colony. Also, Natal, the laws in Natal, although the laws in Natal, you should remember that they were different from any other laws, right? And they were only adopted in the year 1859. So you must remember the English came 1806, started their war in the Cape Colony, but they could only exert their rule and also made laws in Natal in the year 1859, right? And they were using the English law. Okay. Now, there was also laws from Transvaal, like I've said, and Orange Free State had their own laws. But what we need to understand is that the laws that were applied in the Cape Colony, in Transvaal, in Orange Free, were different from the laws that were applied in Natal, which is today called KwaZulu Natal. So they were different for whatever. But things changed on the 30th of May, 1961. Things changed. That's when now all the laws in South Africa, all the evidence laws in South Africa, were now codified into one law, right? They were codified into one law, right? So things changed. So that is what we are doing up to this day. Hence, there was this Evidence Proceedings Act 25 of 1965. We are still working on that act up to this day. This lesson is based on that. Right. So the book that Dr. Naidu has recommended, it's a book called The South African Law of Evidence. It's a 3rd edition. It's by 2 friends who are both professors at the University of Witwatersrand, which is called now Wits. They were professors there. It was a guy called Professor D.T. Zeffert. That is D.T. Zeffert, and his friend is A.P. Pizes. They compiled this, and they compiled that book in conjunction, and publish it with the LexisNexis. That is now the 3rd publication. I think it was done in the year 2009. So you can imagine, when you go to that book, although it has so much, But at the same time, that book was that edition was compiled in what year? In 2009. So it's been, now we are in the year 2023. So a lot has changed, but not drastically. It's still relevant. It is still relevant. You can still refer to it and use it, because as far as I'm concerned, that book is a source of all the knowledge that you need in order to be a reputable litigator, right? Because it interprets all the consolidated different evidence laws from the previous colonies, which were changed in 1961 during what was called the Union of South Africa. The Union of South Africa was in 1961. So things then changed. But now we've got something called the Constitution, that is now Act 108 of 1996. So every law in South Africa is now subject to the 1996 constitution, right? And before that, there was the interim constitution. The Mankwanyana case, for instance, was based not on the constitution, because the constitution only came in 1996. So it was based on the interim constitution, right? The interim constitution, which was sort of replaced or repealed by Act 108 of 1996, the present constitution. So now I think everybody's clear with the sources. Where do we derive these laws of evidence in South Africa, right? Right. Okay. Yes, student. Then what we need to understand as well is that there is something called the philosophy of proof, right? That if you want a particular result or a particular decision, then you must prove that the evidence that you have laid must result in a particular desired result, right? That is the duty of persuasion, because as an attorney, as an advocate, you will have to go to court to persuade judges to agree with your argument, whether it's argument against or argument in your favor. So this philosophy is derived from three philosophers, right? Or the philosophers or writers of philosophy, right? The other one is Sir Richard Eggleston, right? That for any judgment to be successful or argument to be successful, we need what is called philosophy of proof. We need to prove that indeed, if we say somebody was murdered, that person has to be dead, certified dead by a doctor. That is philosophy of proof, right? And but there are other philosophers who argue that we need other methods of proving our argument. So at least one very prominent writer of the subjects, Richard Eggleston, argues that indeed we need to abide by the philosophy of proof, right? He then examined the rivalry of two systems of probability, right? One, he called it the classical, right? The classical probability, and as the other one, the mathematical. That is, now we know in mathematics that 1 plus 1 has to be 2. It can't be anything else. So you can think of fingerprints, you can think of DNA, you can think of bank statements. If a bank statement says on such and such a date you transferred R1,000,000 to a thief, nobody can argue that. That's mathematical. It's scientific, in other words, because maths is a science subject. Those he referred these two systems as Pascalian system, and the others was supported by another writer called Jonathan Cohen, and that one was called the Baconian system, right? So Eggleston demonstrated by the use of illustrations that different perspective and different result follow in an evidentiary context from the use of each of the two systems, right? So you can prove or disprove. That is what this means. You can prove that no, it's not. For instance, I gave you an example in class of a policeman who killed his girlfriend, right? But when the doctor examined the corpse at the mortuary, negligently or by mistake, they brought a body of a man, and he examined a man and made a report based on the body of a man, and yet the person who was killed was a woman. There is no argument that somebody was killed, but the evidence that is there to support the argument of the state or proving the case beyond reasonable doubt is based on a wrong assumption. That is a problem. So that person cannot be convicted based on wrong evidence, although it's a mistake, but it was wrong. Therefore, the purpose of this module, that is not the law of evidence module, will be to enable a student, right, to be able to apply the provisions of the rules of evidence. So you must know the rules of evidence, and you must also be able to apply the rules, because there's something called irrelevant evidence, evidence that has got nothing to do with this. You can't just go to court and start attacking the character of a witness or the character of the accused. That is not allowed. There is also something called the exclusionary rule, that some evidence, right, although they might seem relevant, but the manner in which they were obtained make them to be excluded. For instance, if there was evidence that was sourced by way of torture or misrepresentation, or the accused was induced into making a confession, that evidence, although the accused might be telling the truth, but the manner in which it was sourced makes it inadmissible. So You need to know the provisions of the rules of evidence and also be able to identify the applicable sections of law, that is now relevant legislation. For instance, in the case of Prince versus the president of the Law Society of Good Hope, you can go and look at that case. I may not have the citation now, but in that case, it was decided that the smoking of marijuana by Prince as a way of abiding by his religion, that is the Rastafarian religion, it was declared as unconstitutional, right? That the legislature had erred in saying that it was wrong for Mr. Prince to smoke marijuana in his private space, at a private place, in his own house. So the constitution said that the court said that I was unconstitutional. So it then gave 24 months to the legislature to go and rectify that law. So a high court in the Cape of Good Hope made a decision which was irrational. It was correct, right? But the only problem is that the High Court does not have the power, it does not have the mandate, right, of confirming anything to be unconstitutional. It's only the Constitutional Court, right? When it comes to matters of constitutionality, it is only the Constitutional Court that has to make that determination. So if you read section 172 subsection 2 of the Constitution, it will tell you that only the Constitutional Court has a right to make any determination around unconstitutionality of any act or of any legislature, right? So that is now the relevance of that. So for you to argue that the court was wrong, so then you will go to section 172 and say, because of section 172, I think the court erred in deciding that this matter has to be declared unconstitutional and it must be taken to the legislature, that is not to the parliament, so that there will be an amendment. That is not the High Court prerogative. It is the prerogative of the Constitutional Court, right? Another important aspect that this module has to ensure is that you will be able to establish what procedure is to be followed when intending on leading specific types of evidence. You can't just go to court and just read to the record a particular evidence which you think will assist your case or your argument. There is a manner in which it has to be brought to court. How do you do it? Because as an attorney or an advocate, you are not a witness, right? You cannot witness anything, but you can lead evidence, right, to help your argument. You cannot testify. You must be very careful that it is not your duty to testify. Only witnesses, only your client. Once you place him on the witness box, then you will have to lead evidence. Do not put words in his mouth. You will lead the evidence. You will ask questions like what, how, right? And then the person will then narrate the story, because it has to be said by him. It's not for you. to put words in his mouth. You must be careful of the questions. You must ask open-ended questions, right? So that the person can narrate the story, right? You don't, the questions that says yes or no when leading your witness are not allowed. It has to be the story. But tell the court, what happened on this day, right? The key word there is what. Tell the court what happened on this day. And the person will start narrating the story that we were at the shebeen and there was a fight and somebody pulled a gun and shot. That's the story. And then what happened next? What else can you tell? Is there anything else that you need to tell the court? You let the person say, make the oral evidence under oath. It has to be under oath. So that is why now you must establish the procedure and make sure if anything is wrong, you need to rectify at the same time. But my other warning is that if you see that the other side, your opponent, is making mistakes, do not correct those mistakes. Let them make mistakes, and then later on, when you do your legal arguments, then you can raise that in order to, even if the court does something irregular. But like for instance, you'll be given a list of witnesses, and your client knows the witnesses, and he will just lift up his hand and say, and then the judge will say, approach the bench, approach the dock. Then the client will say, but people are there are witnesses who are here and they are going to jeopardize our case. It's going to be very easy for them to corroborate what this witness is saying. So let's say there are 3 witnesses in the case. One is in the stand and the other 2 are seated in court. That is irregular. But you don't raise it as an attorney. You don't raise it, you let it go. And once they get into the box, then you will say, yes, after they have been sworn in, and then you will just confirm that, where have you been sitting while Mr. So-and-so was leading his evidence? And the witness will say, no, I was just seated here in court behind you, Your Worship. And then you will stop right there and say, this whole process is irregular. So I was just want to make an application that it must be dismissed because it is irregular. You don't advise them, to correct. If you see anything wrong, you capitalize on it, right? So you establish what procedure is to be followed when intending on leading specific types of evidence. So there will be there will be documentary evidence. What is also important that any evidence, including a statement by your own client, say you've got a statement, a 115 statement where your client is denying everything, you've got to hand it in as exhibit. You can't just read it and then let it lie. Otherwise, it's just as good as if you haven't said anything. You've got to hand it in as exhibit, right? Whatever document that you want to use to prove or disprove your case, you will have to hand it. It must be marked as Exhibit 1, Exhibit 2, and it has to be on record as having been handed over. So those are the procedures that you need to follow when leading certain types of evidence, right? Expert evidence, you will call your witness to give expert evidence, or be it ballistic reports or forensic report, or sometimes writing expert in order to determine whether the signature on that document belongs to your client or to the other side. So you must establish the procedure how to do that. that information has to be handed in as exhibit. That is what is important, right? And also you need to decide what evidence is necessary to prove or disprove certain facts in the dispute, right? So you will decide if, for instance, you are a prosecutor and you want to prove that, yes, indeed, Mr. Ntombela's wife phoned somebody that is not known to him, somebody whom, according to the evidence before court, was suggested by a friend of hers to say, if you want to kill your husband, Mr. Ntombela, you must call this number, right? It's that which means that they are calling a stranger. You call this number, and this person will help you with the kill. And now you want to prove that. What do? You use the section 205, section 205 of the Criminal Procedure Act. Go and make an application to have those two numbers that called each other. Say it's a Vodacom, the other one will be Vodacom, the other one will be MTN. You get an order from the magistrate or judge in court, and you take that order to these service providers, Vodacom or MTN, and ask them to verify if there was a call on a certain date or on which date that says this accused called the other accused, or accused number one called the accused number two, even though there is no conversation, but at least the court will prove that there was communication before the death of the deceased. But it's even worse when there is WhatsApp, because if there is WhatsApp, then you as the prosecutor will be able to see the actual conversation, and saying, go to a boy's tavern. My husband is there. I've seen that he's the only one that's wearing a red T-shirt, and he's wearing a bowler hat. So you will go, then the killer will go there, although they don't know each other, then he will go and kill the person with the red shirt, with the bowler hat. The WhatsApp will then establish, right, your allegations. It will then confirm your allegations, right, where you prove or you disprove. So you need to decide which evidence you want. All right. And then what is very important is that, like I've said, some evidence will be admissible and others will not be admissible. Now, it is the duty of a litigator to deal with the issues of admissibility and relevance, right? Admissibility and relevance. So you need to know, but okay, this evidence has been laid, but it is not relevant. It's not helping the process. It is not helping the court to come to a decision. Inadmissible evidence will be hearsay evidence on certain conditions, and but as you read the rules of evidence, you will see which evidence are admissible and the kinds of evidence: oral evidence, documentary evidence, illegally obtained evidence, when using the exclusionary rule. And the exclusionary rule will be section 35, subsection 5 of the Constitution. It deals with it's called the exclusionary rule. Exclusionary rule. So you will exclude relevant evidence just because the manner in which that evidence was obtained is unconstitutional. Then it is not admissible, although it is relevant, right? So, but we will deal with that when we come to types of evidence, when we deal with relevant evidence, admissible evidence, inadmissible evidence. Right? Now, I know that Dr. Naidu has told you this, right? That what are the intended outcomes of this module, right? This module will help you to organize and manage yourself effectively, especially when it comes to dealing with evidence. You'll be able to collect and also understand, analyze information from various sources of law, right? In addition to information conveyed by us as lecturers, right? You will always you will be able to take what we've told you in class and use it in order to practically practically get that information that you need, right, in order to be able to argue your cases. That means we are now preparing you for practice, for the real world, right? And you must also be able to recognize problem-solving contexts involving criminal procedure, and also identify and solve problems, and be able to communicate. You must be able to present your story, your case, right? You will start by doing it in my class, the legal practice class, where you will be taught how to communicate effectively, right? In my class, and also be able to draft. I know you did drafting in your second year, but you must show that you are now able to draft your summons, draft your, if I say do the particulars of claim, you will do that. So another example of the manner in which you lead evidence. For instance, in the case of divorce, you must have particulars of claim. Particulars of claim will be who are the parties, who is the plaintiff, who is the defendant, how many children do they have, do you want the pension of the other spouse, do you want the property to be divided in 50-50 or 40-60, depending on how your settlement agreement has been drafted. So in that case, the manner of you leading that evidence before you hand it in as exhibit, you will then make the keyword that we will say, do you confirm? Do you confirm that the plaintiff in this divorce case is Miss Nokulunga Ndlovu? Do you confirm that the defendant is Mr. Sipho Ndlovu? Do you confirm that there is 2 children out of this marriage? Do you confirm that this marriage was consummated on the 17th of March 2023? Do you and then the witness will be confirming that's it. Yes, I confirm that. Yes, I confirm. You'll just confirm, and you'll confirm that the marriage between the plaintiff and the defendant has reached a stage of irreparable damage, and then she will confirm. So that's how you lead that particular evidence, right? So you must also be able to recognize, now coming to what you need to know after we have gone through this law of evidence course. You must be able to recognize problems, solving contexts involving criminal procedure, identify and solve problems, communicate effectively, and develop independent research skills. Now we are teaching you how to do it, but you must also develop your own research skills, including the use of your iPhone and the use of your electronic library. You will get, the Law Society in Pietermaritzburg has something called the electronic library. Once you are admitted as an attorney or advocate, you can then apply to have access to the electronic library in Pietermaritzburg. So you don't have to buy all these law reports like how we did during our years of practice. We'll buy all this. All now you can do because you were born in 2002. You just apply in Pietermaritzburg. Director Mfusi in Pietermaritzburg will help you have access to the electronic library that is there for lawyers who pay subscriptions to the LPC, right? The LPC is the Legal Practice Council. The offices are in Pietermaritzburg and in Durban as well. There are offices there at the Marine Building. There are also offices in Pietermaritzburg. Right. So I need to emphasize on the rules of evidence and the requirements for admissibility. What are the requirements? What needs to be there in order for you to confirm that this particular evidence is admissible in a court of law, right? And also you must be equipped with understanding legal concepts of the law of evidence, right? And also you must have an intensive understanding of the purpose and constitutional effects of the law of evidence in changing the socio-political contents in the new South Africa. So it is important that you need to understand that the Constitution, at its inception in 1995 or 1993, if you like, because the interim Constitution was, I think it's a 1993 Act, if I'm not mistaken, and then it was repealed by the 1996. The bringing about of the Constitution changed the way evidence is sourced from the accused person. Before, there was something called interrogation. The word interrogation, once you come to court and you ask the IO, did you interrogate the accused? And the IO, not knowing the meaning of interrogation, will of course say, yes, we did interrogate. And you need to stress on that. This Constitution doesn't allow interrogation, because interrogation means torture. If you read if you look at the word interrogate, it takes us back to the apartheid era, yes, where people were interrogated, were beaten. So in the new South Africa, the socio-political terrain has changed, and you can now, people have rights, in the Bill of Rights, that you cannot implicate yourself. You cannot. You must always have a lawyer by your side. So if an IO goes and tells a person to make a statement without the assistance of a lawyer, then that statement can be rejected, because the person has a duty to sign in front of that IO to say, I want to make this statement, I want to implicate myself. And he must be told that he does not need to implicate himself, right? So Also, the example that I gave you, where somebody is deceived by misrepresentation, he is made to make a confession. I gave you an example of that chicken murder, where somebody slaughtered a chicken and went to the accused's house and spat blood on the walls, and came to the accused and said, yes, you killed your girlfriend, and you cleaned the whole surface, that on the floors we could not see any blood, but unfortunately there was this small spot on the wall that you forgot to erase. So are you still saying you did not? And he then said, oh my God, I am caught. And then he gave a confession and said exactly what happened, collaborating other witnesses that were brought by the prosecution to prove his case. Although that that evidence was obtained through misrepresentation, the court was reluctant, very reluctant, to accept it as inadmissible, because it corroborated what other witnesses were saying, but it was incorrectly obtained. Now, it is for the court not to decide whether to use it in what is called aggravating circumstances of the matter, of the case. So that is why they say there is no conclusive legislation that says this particular evidence must be excluded. It is the discretion of the presiding officer, of the discretion of the court, that will decide whether to totally exclude evidence, although you can see that the evidence is relevant, but it was unlawfully obtained, but it is corroborated by other witnesses. Then it is up to the presiding officer to decide whether to accept it or reject it, right? So the other outcomes of this course will be to enable you to apply the general principles of the law of evidence, right? And also involve application, interpretation, and enforcement of rights and obligations of each role player, right? And also you'll be able to apply the theory acquired to arguments that are sound in fact and in law, in order to be successful in your work as a litigator, right? And after you have completed this module, you must be able to identify the different types of evidence. You must know, when you look at that evidence, you must say, oh, this is circumstantial evidence, this is documentary evidence, this is oral evidence. You must be able to identify those types of evidence, right? This is evidence. This is evidence that has to be excluded, this because of relevant, irrelevant, and relevant evidence, right? And also you must be able to identify the rules of evidence applicable to a specific type of evidence. And then you will say, what are the rules that must be adhered to or followed when dealing with hearsay evidence or circumstantial evidence or documentary evidence, right? And how do you, because you cannot just go without a court order, go and invade the privacy of the accused by doing what? By sourcing out information from his cell phone records and use that in court in order to implicate. Although you will see that you've got friends at Vodacom, you know they can get this information for you and bring it to court so that you can implicate the accused. But the manner in which that relevant evidence was sourced tends to be rejected because you failed to use the section 205 principle of 205 of Criminal Procedure Act, that you need to go to court, apply for an order that allows you to invade the privacy of the accused in order to get information that will implicate the accused. So you must be able to identify the rules of evidence applicable to a specific type of evidence, and also you must be able to apply the rule to the specific evidence, to say this evidence, because it is hearsay, it is only said by a policeman, so therefore it cannot be accepted. But you must be careful. Hearsay evidence is allowed and admissible in the cases of where you apply for bail, right? You must never say, no, policeman, what you say, you were not there when the person was killed. What you say, you only heard people saying that, so you don't know about this, how this person was killed. That evidence is admissible, right? You must be able to present the evidence in a correct manner. Like I've told you, that you can't just bring evidence anyhow. You can't testify on behalf of your client. Your client must be on the witness stand, sworn in, and do what and done what, and also make his own statement. You don't put words in his mouth, right? You must also be able to present argument for the admissibility, inadmissibility of the evidence. You say this evidence is not admissible because of these reasons. You can't just say it's inadmissible and then you don't support your argument. You must always support your argument. And also, whenever you're making an argument, you need to support your argument with case law and legislation. That is very important. You support the case law and legislation that the law doesn't allow. Like I told you about section 172 of the Constitution. That's 172 subsection 2, that says for the High Court to be correct in its system, it has to refer that decision to the Constitutional Court in order for the Constitution to make that determination, to say this matter must be taken to the legislature for repeal or amendment, right? That particular section, which is unconstitutional. So, and also you must be able to prove your case by presenting evidence that is relevant, that is admissible, and do so in a proper manner, right? Respectfully, to say. Okay, then at least I know now you've got the overview, know exactly what is done. I am not going to repeat all the topics that Dr. Naidu told you, because I think I have covered most of what he said, right? I'm not going to do that. Let me now try and jump to topic, I think it will be topic number 7, if I'm not mistaken, because I understand that you've gone from topic number 1 to topic number 6. So now let us go to the next one.